The application of the following materials, including the cleaning, priming, and preparations of concrete floor spaces and surfaces, to receive concrete stain, sealers, curers, hardeners, and waxes, the aforementioned materials included in concrete prior to pouring or in the finishing process performed during the curing period not to exceed 1 week is the work of the cement masons. Affidavit of Andrew T. Galanti, Exhibit A, Article 4, Section 4.4. When Corbetta continued to assign laborers to do the spray curing work, bricklayers filed suit in the New York State Supreme Court seeking injunctive relief to have the spray curing work assigned to it on the basis of the quoted contractual provision. Bricklayers was granted a temporary restraining order which required Corbetta to employ only bricklayers for the masonry work on the bridge. That order was subsequently modified to provide that the spray curing work would be equally divided between laborers and bricklayers. After the state court denied Corbetta's motion to dismiss the complaint on the ground that the National Labor Relations Board has exclusive jurisdiction of the subject matter, Corbetta removed the action to this court. Meanwhile, the laborers had complained to the NLRB that bricklayers had violated Section 8B, paren 4, paren D, by its strike and picketing in connection with the jurisdictional dispute over which the union would do the spray curing work. The NLRB held a hearing pursuant to 29 United States Code, Section 160K, in June 1980, and on October 28, 1980, the NLRB rendered its decision awarding the spray curing work to the laborers. On December 15, 1980, the work on the Newburgh Beacon Bridge No. 2 was completed. Laborers moved to intervene as parties defendant pursuant to Federal Rules of Civil Procedure 24A, paren 2, to vacate the order that Corbetta employ both bricklayers and laborers for spray curing, to dismiss the complaint on the ground that the NLRB has exclusive jurisdiction, and for an order requiring Corbetta to employ only laborers for spray curing. Laborers contends that it is entitled to intervene because it has a direct interest in the assignment of the spray curing work which bricklayers claims should be assigned to bricklayers. It argues that its ability to protect its interest will be impeded by any disposition of the case in its absence, and that Corbetta, as the employer, cannot adequately protect its interests. Bricklayers answers that the motion to intervene should be denied because laborers' legal arguments are identical to those made by Corbetta, and Corbetta has already shown in the course of this litigation that it can adequately protect the interests of the laborers. Bricklayers also argues that it will be severely prejudiced if laborers is permitted to intervene because it will then be required again to defend against a motion to dismiss on the ground of the NLRB's exclusive jurisdiction. Laborers' motion to intervene is granted. Under Federal Rules of Civil Procedure 24A2 and 17, one is entitled to intervene in an action when the applicant claims an interest relating to the property or transaction which is the subject of the action and is so situated that the disposition of the action may be, as a practical matter, impairing or impeding his ability to protect that interest unless the applicant's interest is adequately represented by existing parties. Laborers' direct interest in the case is clearly evidenced by the fact that the state court temporarily divided the spray curing work between it and bricklayers. The ultimate resolution of this dispute must entail an award of this work to either bricklayers or laborers, not both. Moreover, laborer's ability to protect its interests may be impaired if the action is resolved in its absence, in light of the fact that Bricklayers is seeking to permanently enjoin Corbetta from employing anyone who is not a member of Bricklayers for the spray curing work. It cannot be expected that Corbetta can adequately protect laborers' interests. As the employer, Corbetta stands in the middle of a jurisdictional dispute, which is essentially between the two unions. You should have gotten a few words in your dictionary there. Do you have the word curing?
I'm not sure. Yeah, I do.
How do you get that?